Hello there, my name is Oliveira. I'm a Brazilian attorney, also licensed in California and Texas, and today I'm going to answer this question. What are the main distinctions between collecting debt from a consumer or a company in Brazil? So let's start by the legal framework. There are different laws addressing the collection of debt when it comes to consumers and companies, and in Brazil there is a highly developed body of law protecting consumers. Yes, there are consumer agencies in the United States, for instance, but there is no such a federal across-the-board regulation protecting consumers. And from this perspective, there is the first big distinction between collecting from consumers and collecting from companies. There is going to be a lot of more protection against collection on consumers than there is on collection on companies. So whenever collecting from consumers, the collection is going to be based more on the Consumer Protection Code, o Código de Defesa do Consumidor, like we say in Portuguese. And on the other hand, when you're collecting from companies, the disputes are going to be based on the Civil Code and commercial practices instead. So this is also going to impact on the negotiation techniques or approach. For consumer, you're going to need to follow a more narrow set of practices, and just like in the United States, you're not going to be able to, harass or, not harass, but maybe, to keep calling or emailing non-stop like a debtor. If the debtor says they want you to stop communication, you need to stop communication. And on the other hand, when you're collecting from companies, such provisions will not usually apply. In terms of documents and evidence, of course, you want to have your bases covered on both cases. In consumer cases, for instance, you should have solid paperwork to avoid a potential counterclaim if your collection is not really solid. And for commercial disputes, when a lawsuit may be needed, you don't want to file a lawsuit to lose the lawsuit later on. In Brazil, unfortunately, there is the so-called honorários de sucumbência, which may be triggered when you lose a cause, costing you up to 20% of the amounts that you are trying to collect. Something somewhat new in Brazil is the credit score. Up to a couple of decades ago or 1 decade ago, we wouldn't have a credit score. Instead, we would have either a clean file or a non-clean file. And nowadays, because of a partnership between Serasa, which is like the main Brazilian credit bureau, and believe it or not, the US Experian, we have a credit score system somewhat similar to what you would see in the United States. Here again, if you are in the process of understanding how Brazilian buyers operate, you should factor into your process to get a credit score as part of your credit analysis in order to give this potential buyer the right amount of credit. Let's talk about some of the foreign creditors' perspectives here. Consumer debt collection, particularly when you are dealing with many consumers, may trigger special attention from the consumer protection agencies, and therefore you should never try to do that by yourself. Instead, you should hire a law firm to make sure you're following all the regulations and laws, and you are avoiding, again, the chance of a countersuit to collect damages based on what you did that you shouldn't have done in terms of collections. For commercial debt collection, particularly for larger amounts, there are many techniques that you can use, such as the protesto and other negotiation techniques to try to avoid a fully fledged lawsuit. Consider scheduling a consultation with our firm to learn about our collection techniques and follow us for more tips.